right, welcome. Welcome to Understanding the Basics of the Migrant and Seasonal Agricultural Worker Protection Act. My name is Jackie Schweichler, and I'm a staff attorney here with the Penn State Center for Agricultural and Shale Law. The Understanding Agricultural Law Education Series is a course designed to provide subject matter literacy and competence on fundamental issues of agricultural law to attorneys and business advisors who work with or represent agricultural or rural clients, but who may not specialize in agricultural law. This series is sponsored by the Pennsylvania Department of Agriculture's Ag Business Development Center, established through the 2019 Pennsylvania Farm Bill. The Agricultural Business Development Center aims to enhance the long-term viability of Pennsylvania farms by supporting farm transitions, both from generation to generation and from conventional to organic farming, supporting beginning farmers, providing risk management education, and providing financial assistance through grants and low-interest loans. We've covered numerous topics in the Understanding Agricultural Law Education program, including ag labor, finance, conservation programs, and Pennsylvania's Clean and Green program, and many, many more. You can find materials and recordings from all of these programs on our Understanding Agricultural Law landing page on our website at aglaw.psu.edu. We encourage you to mark your calendars and register for our upcoming programs. In our Understanding Ag Law Education Series, we've got Pennsylvania's Clean and Green Program, County Level Administration. That's on June 27th, 2025. On July 25th, we have ADA Compliance for Agritourism Operations. That's with me. And on August 22nd, we have Foreign Ag Land Ownership Laws. All of these programs are on Fridays at noon Eastern Time, and attorney CLE credit is available for all of these programs. You can register for the Understanding Agricultural Law landing page, or you can register on our events page on our website. We also have our quarterly dairy legal webinar series, and our next webinar under that program will be Tuesday, July 15th. And in that program, we'll cover the second quarter of 2025, and the focus topic will be the 2025 Federal Milk Marketing Order reforms. That program will also be at noon Eastern Time, and attorney CLE will be available. In a couple weeks, we have another program lined up with our partner, the National Agricultural Law Center. That'll be on June 18th, and Director Ross Pfeiffer will present an overview of state grain dealer statutes in the United States. It's going to be an excellent webinar, but please note that attorney CLE is not available for that program. And then one last plug, registration is now available for our 2025 Pennsylvania Agricultural Law Symposium. This symposium will be held in person in University Park State College. We'll provide lunch and refreshments. Though you can get 6 attorney CLE credits, tentative topics that we are talking about covering agricultural labor, Pennsylvania acre right to farm, environmental natural resources, agribusiness issues, 2025 Ag Law update, and more. And again, that is on Thursday, September 18th, 2025. Oh, and there's early registration pricing I want to mention. It's $150 for attorneys requesting a CLE, $100 for non-attorneys, and then $25 for students. And make sure to register soon so you can get that nice early bird pricing. And we will hopefully see you in person in September. And I see that someone has raised their hand. So before I go to the next thing, if you have a question, if you want to put that in the chat or the Q&A, I can get back to you on that. Okay. And finally, just a few reminders before I turn this webinar over. This webinar is being recorded. If you have any questions, please write them in the Q&A feature, and I will collect those and ask those at the end. Also, we encourage you to fill out the poll at the end of the webinar. Tell us what you liked, tell us where we can improve, and what topics you'd like to see in the future. And if you are interested in CLEs, there's a CLE form listed on the materials page and also separately here in the chat. You will need to fill out this form to get your credits for the CLE. And we can also send you an attendance certificate that you can submit to your state's CLE board for those of you who are not licensed in Pennsylvania. And as part of our responsibility to ensure attendance, we will provide a code word later in the program that you must enter into the form. If anyone is calling in, and I don't see that right away, but if you're calling in and you don't have access to the CLE form, please send me an email at jks251@psu.edu. And turning things over, Audry is a staff attorney with the Penn State Center for Agricultural and Shale Law and serves as the program director of this Understanding Agricultural Law education series. And she is the primary author of the Agricultural Law Weekly Review. Audry, the screen is yours.
Thanks, Jackie. Okay, everyone hear me? And is my,
Yep, looks good.
good? Okay, let me just one thing here. That is so much better. Okay. All right. So let's talk about the Migrant and Seasonal Agricultural Worker Protection Act. I feel like I need to preface this with saying I think the biggest issue right now facing producers is certainly just access to labor in general. But this is part of this series, so we're just going to cover this law, what it does, and so on and so forth. So today we'll talk about the history and purpose of this law, who it applies to, who it doesn't apply to, what it does, creating employer responsibilities, and then therefore employee rights in conjunction with those responsibilities. Enforcement issues and issues around joint employer liability. And then I've got one recent case that we'll talk about a little bit. Before we get started, I guess we're already started. In my research for this presentation, I came across 3 different acronyms used to refer to this law, the Migrant and Seasonal Agricultural Worker Protection Act. I have seen it referred to as MSAWPA, as AWPA, so the Agricultural Worker Protection Act, and then MSPA, because MSPA is the acronym that the Department of Labor uses and is currently using, and that's what appears on all of their websites and all of their publications. I'm going to use MSPA, but just be, I guess, where sometimes you might be reading a court case or something and they'll refer to it as the AWPA or something like that. So, but throughout this presentation, we're talking about the MSPA, the Migrant and Seasonal Agricultural Worker Protection Act. Okay, so when we're talking about ag labor in general, ag workers are generally exempted from other labor laws like FLSA, Fair Labor Standards Act. I apologize for the overuse of acronyms, and the National Labor Relations Act. And that creates some underlying issues just inherent in I guess the work itself and the nature of these workers, particularly language and geographical barriers between the operators and the laborers. And so William Whitaker has a wonderful CRS report out that's talking about kind of the history of this law and then the law that preceded it. And he wrote, the farm labor contractor or crew leader is the bridge between the farm operator and the migrant laborer. Farm operators, so this is back in the 60s, 50s, farm operators would go south each year to meet the crew leader and arrange for migratory crews. The crew leader solved the owner's problem of recruiting and managing labor. So a lot of times the crew leader, this is often in Mexico, the workers would all be there. And so you'd have a crew leader who would be in charge of a crew of people, many of whom did not speak any English. And then when they came to the United States, they were in a foreign country. So this is just a situation rife for abuses. And in the 50s and 60s, there were a lot of problems going on with this setup, and the list of alleged abuses associated with farm labor contractors appears to have been as long and varied as those engaged in the field, Whitaker writes. In the 1961 hearings for the 1964 law, we'll talk about in a second, William Batt, Pennsylvania Secretary of Labor and Industry, noted the then standard complaints. He noted changing wage rates without explanation, exploitation of child labor, illegal sale of alcoholic beverages, charging the workers a rental fee on housing provided for free by the grower, food profiteering in crew leader operated commissaries, hunting deer out of season, shooting and beating up other crew leaders, rigged crew leader operated gambling games, paying crew members in scrip in lieu of cash, and charging exorbitant transportation fees. So there was a lot of unsavory activity going on, and Congress at the time was looking to tamp down on that. So in 1964, the Farm Labor Contractor Registration Act was passed. The only reason I mention that is because it is the predecessor to this law, and I think it's informative to know that it was originally enacted as a law aimed at farm labor contractors. Now it encompasses ag employers, and we'll talk about that too. So MSPA replaced that Farm Labor Contractor Registration Act in 1983, and it was trying to resolve the ills inherent in a workforce that doesn't live where they work and oftentimes doesn't speak the same language. And so Congress wrote in the statement of purpose here, it's a purpose to remove the restraints on commerce caused by activities detrimental to migrant and seasonal agricultural workers, to require farm labor contractors to register, and to assure necessary protections for migrant and seasonal ag workers, agricultural associations, and agricultural employers. So Congress is actually trying to protect ag employers to a degree with these laws. I also like to note here that I like when Congress gives a statement of purpose. Sometimes they don't do that. And I like that they're also invoking the Commerce Clause because that is how they have the power to enact this law. So who does MSPA apply to? It applies to, if we go back here, there's essentially three groups of persons that this statement and then the law is referring to throughout. We've got ag employers and ag associations, farm labor contractors, ag employees and associations and their employees, farm labor contractors and their employees, and then we have migrant ag workers and seasonal ag workers. So let's start actually with the workers themselves and talk about who they are. So a migrant agricultural worker is an individual who is employed in agricultural employment of a seasonal or other temporary nature, and who is required to be absent overnight from his permanent place of residence. So more words to define there. So we've got permanent place of residence. Hang on one second. Okay, yes. Okay, good. Permanent place of residence for the purposes of the Act means domicile or permanent home. It does not include seasonal or temporary housing like a labor camp. And for any non-immigrant alien, that is going to be that individual's country of origin. So if we go back here, so someone who's required to be absent overnight from their permanent place of residence. If you are familiar with the current labor force in agriculture today, you may be thinking that doesn't describe a lot of workers, and you would be right. USDA ERS says yes. More farm workers are settled and fewer are migrants. That's what ERS says. According to ERS, 83% of hired crop farm workers, this is crop, are not migrant workers but are considered settled, meaning they work at a single location within 75 miles of their home. This is up from 41% in the mid-90s. ERS also identifies another group that they call shuttlers who work at a single farm location more than 75 miles from their home. They might cross an international border to get to their work site. According to ERS data, shuttlers made up about 9% of hired crop farm workers in 2022. That number is down about 24% from the mid-90s. And the more common in the past, the follow the crop migrant farm worker, who is really who is being described in this statute or in this regulation here. So the follow the crop farm worker who moves from state to state working on different crops as the seasons advance is now a relative rarity. These workers made up just 4% of those surveyed by the National Ag Worker Survey in 2020-2022, and that's down from a high of 14% in 1992-94. So 4% of ag workers or crop workers would fall into this migrant category, but there's still seasonal agricultural workers, and that's probably going to be what's driving this law to trigger. So a seasonal agricultural worker is an individual who is employed in agricultural employment of a seasonal or other temporary nature and is not required to be absent overnight from his permanent place of residence. When employed on a farm or ranch performing field work related to planting, cultivating, or harvesting, or when employed in canning, packing, ginning, seed conditioning, or related research or processing operations, and transported to or from the place of employment by means of a day haul operation. That's a lot. Now we'll get into the field work related to planting. I think that's kind of obvious. But let's talk about this day haul operation. So that would also render someone a seasonal agricultural worker if they're part of a day haul operation. And that means that the assembly of workers at a pickup point waiting to be hired and employed, transportation of such workers to agricultural employment, and the return of such workers to a drop-off point on the same day. So workers who are engaging in that activity would fall under the Seasonal Agricultural Worker Act. This term does not include transportation provided by an employer for individuals who are already employees at the time they are picked up, nor does it include carpooling arrangements by such employees which are not specifically directed or requested by the employer or the farm labor contractor or whoever is employing them. So if you've already employed workers and you are providing them transportation, that is not a day haul operation. This is, I think a lot of times we see this in construction where workers will gather and they will wait for someone to come and pick them up and take them to a job that they did not know existed that morning. Okay, so if we kind of compare migrant ag worker and seasonal ag worker, a migrant ag worker is required to be absent. A seasonal ag worker is not required to be absent. Both are doing work of a seasonal or temporary nature. So let's talk about that. Seasonal employment is performed at certain seasons or periods of the year and from its nature may not be continuous or carried on throughout the year. A worker who moves from one seasonal activity to another is employed on a seasonal basis, even though they may continue to be employed during a major portion of the year. That is really describing that ERS, follow the farm type worker, which according to ERS is 4% of workers today. I also read in several secondary sources that seasonal temporary work is defined as less than 1 year. That less than 1 year language is not actually in the regulations. The regulations say may not be continuous or carried on throughout the year. So I think that's where we're getting that less than 1 year. There's a slight difference. Okay, so seasonal or other temporary basis. Let's talk about other temporary basis. I'm not sure if the regulations are super helpful here, but they do define other temporary basis as employed for a limited time only, or performance is contemplated for a particular piece of work, usually of a short duration. The regulations do contrast seasonal and temporary work with general employment, which they consider to be not temporary. So when we're talking about employment and we say the word employment, it's considered to be permanent or not temporary. And that's why we're carving out this seasonal or other temporary work. Okay, what does seasonal or temporary work not include? It does not include the employment of any worker who's living at his permanent place of residence when that worker is employed by a specific agricultural employer, so like a farm or association, on basically a year-round basis to perform a variety of tasks for that employer and is not primarily employed to do field work. This, to me, sounds like dairy and other things, but particularly for our state and our audience, this sounds like dairy. Seasonal and temporary workers also, just for the record, do not include H-2A. And I think that's, whenever we hear the word migrant in this act, I think maybe lay people might think H-2A. When we're talking about this act, MSPA, we are not talking about H-2A workers. In fact, for both migrant ag workers and seasonal ag workers, the regulations specify directly that MSPA does not apply. It also does not apply to immediate family members of ag employers and farm labor contractors. More on immediate family members later. Okay, so we've got our migrant and seasonal ag workers. Those are the employees who are being regulated here. Let's talk about ag employers and ag associations. So we'll talk about kind of the entity first and then what they do second. So if we're looking at like the entity slash person, we have an ag employer is any person who owns or operates a farm, ranch, processing establishment, cannery, gin, packing shed or nursery, who produces or conditions seed, or in the instance of the association, a nonprofit or cooperative association of farmers, growers, or ranchers. So we have these types of entities, people, and they are doing this thing: recruiting, soliciting, hiring, employing, furnishing, or transporting any migrant or seasonal agricultural workers. And then we also have farm labor contractors and their employees. A farm labor contractor is someone who engages in farm labor contracting activity for payment. What is farm labor contracting activity? It is that recruiting, soliciting, hiring, employing, furnishing, or transporting any migrant or seasonal agricultural worker. Specifically, a farm labor contractor is not an agriculture employer, an agricultural association, or any of their employees. So we've got our regulated ag employers, ag associations, farm labor contractors. What employers are exempt from the Migrant and Seasonal Agricultural Worker Protection Act? Well, the regulations list out 10 persons not subject to the act, including their employees. The first, we've got family business exemption and small business exemption. And then there's common carriers, labor organizations, nonprofit charitable organizations, this local short-term contracting activity. I'm going to talk more about family business and small business exemptions, but I'll just note here that local short-term contracting activity, it's any person who engages in farm labor contracting activity solely within a 25-mile interstate radius of the person's permanent place and for not more than 13 weeks per year. So there's like a time and temporal aspect, is that right? Time and place aspect, I guess, of that exemption, local short-term contracting activity. There's also custom combine, hay harvesting, or sheep shearing operations, custom poultry operations. Again, I said I wasn't going to get any of these, but I will tell you in the custom poultry, the regulations do not specify what is custom. It's kind of interesting. Seed production and shade grown tobacco. So the first two are really the most common, so we're going to talk more about those. So family business exemption. The exemption applies to any individual who engages in a farm labor contracting activity. So that's that recruiting, hiring, soliciting on behalf of a farm which is owned or operated exclusively by them or by their immediate family, if those activities are performed only for that operation and exclusively by that individual or immediate family member. Whether or not the business has incorporated is irrelevant. So who is an immediate family member for the purpose of this law? It's basically one generation up or down, close. So we've got spouses, children, stepchildren, foster children, parents, step parents, foster parents, and brothers and sisters. Note who's not here. Cousins, aunts and uncles, grandparents, and grandchildren. So doing farm labor contracting work for your cousin is not going to fall under the exemption, and you would have to register. We'll talk about that in a second. So just I'll do a hypothetical person. John is performing farm labor contracting activities for his brother's farm. He would not be subject to MSPA. But if I go back to this language here, such activities are performed for the operation and exclusively by such individual or immediate family member. So if John starts recruiting for another farm, MSPA applies. If John's brother hires a licensed farm labor contractor who's not an immediate family member, then John's activities are no longer performed exclusively by a family member, and MSPA would not apply to him anymore. He would need to be certified. So lots of, things could happen that would throw you out of the exemption for there. Also exempt from MSPA are small businesses. What are small businesses? They are businesses that fall within Fair Labor Standards Act's 500 man-day rule. 500 man-day rule. A man-day is any day during which an employee performs any ag labor for not less than 1 hour. Examples would be, I think the emphasis here, maybe it should be like the number man day. So if one employee works for 1 hour, that's a one-man day. If one employee works for 8 hours, that's a one-man day. So you had one person working and they met the 1 hour minimum. So it's one guy, one man. If you have 5 employees working for 8 hours, you had five-man day. That's how that, so I think it should be like a 5-man day as opposed to man day. The emphasis seems to be there, but it's really should be the number. So some man day math. In order to fall into this exemption, you have to use fewer than 500 man days. That language is coming out of the minimum wage exemption for ag labor under Fair Labor Standards Act. It defines an employer, such a small farm employer, as one who did not, during any calendar quarter during the preceding calendar year, use more than 500 man days of ag labor. So you have to think about like the last year and then each quarter of that last year, and then whether or not 500 man days was used during that quarter. Department of Labor says that 500 man days is approximately the equivalent of 7 employees employed full-time in a calendar quarter. I've done the math on this. If you had 7 employees working 6 days a week, so 6 days a week. So this might like maybe kind of a peak, you're working a lot. That would be 42. And then 42 times 13, so there's 13 weeks in a quarter, that would be 546. So if you were operating at like 6 days a week for an entire quarter with 7 people, you would come in above that 500 man day threshold. And you would not qualify for the exemption here. And then this exemption here for MSPA would apply to the entire farm. And the entire farm would not be subject to like the disclosure, the posting requirements that we're talking about. Whereas that family exemption is really dealing more with farm labor contracting activity. I think I'll also point out here, you can see how once an operation starts hiring employees, you got to be precise with your record keeping. I think it wouldn't be difficult to hit this threshold pretty quickly. And if you're relying on the fact that you're a small farm to not have MSPA enforced against you, you want to be able to show that, particularly if you're hiring employees. Okay, moving on. Okay, so we've got our regulated persons, we've got ag employers and associations. They are farm owners and nonprofit cooperative association engaging in farm labor contracting activity. With our exemptions, farm labor contractors, they're paid for that contracting activity. Our migrant seasonal ag workers, they are performing temporary or seasonal agricultural work. So what does this law do? What does it establish? Several things. First of all, it requires that farm labor contractors, people who are paid for their activity, they must register with the U.S. Department of Labor. I'm not going to get into registration requirements, just know that they got to be registered. And I'm going to do a quick preview here. So it also sets out obligations for ag employers, ag associations, and farm labor contractors. And in doing so, it creates certain rights for workers to have those obligations fulfilled. These include providing written disclosure of the terms and conditions of employment, posting certain information about worker protections at the worksite, paying the workers the wages they're owed when they're due, and providing an itemized statement of earnings and deductions, complying with the terms of any working arrangement made with the workers, and keeping 3 years of payroll records for each employee. It also establishes compliance requirements for health and or safety for providers of housing and transportation transportation. Those providers may not necessarily be ag employers or ag employer associations or farm labor contractors for that matter, but whoever is providing the housing and transportation, if it is provided, is responsible for complying with MSPA. There's also enforcement provisions of MSPA. including administrative and civil penalties and potentially criminal prosecution, depending on the nature and degree of the violations. More importantly for this law, and we'll talk about this in a second, it establishes a private right of action for workers. So the worker can bring a claim. They don't have to seek relief through Department of Labor or the state. They don't have to wait around for the government to get their wages back. They can go to court and do it themselves. Okay, so let's talk just a bit about farm labor contractor registration. Farm labor contractors and their employees must register with Department of Labor before performing any farm labor contracting activity. DOL will issue them a certificate seen here, and those contractors must carry that certificate around and they must show it to anyone who asks to see it. They must be specifically authorized through DOL to provide housing and transportation. That's like a separate certification authorization process. And here are two examples from DOL of the certification that they issue here. And you can see here, like transportation authorized, housing authorized. Here, it doesn't say anything, driving authorized. This blue one is the employee, and the orange one is the farm labor contractor. So if you're an agriculture employer and you are working with a farm labor contractor, you might want to ask to see their certificate, and you might want to see that it is valid. Department of Labor also maintains a database of registered farm labor contractors. You can go there and look people up. Department of Labor says we no longer publish a list of ineligible contractors. Parties not on this list are currently not registered contractors. And you can see here, I screenshot this the other day. This was valid as of Wednesday. So you can look people up, you can sort and figure out who they are if they're registered. And I will tell you, in Pennsylvania, there are 45 registered farm labor contractors. Only 3 of them have transportation and housing authorization. This is available in the spreadsheet if you want to see it. It's just a PDF, so you can't sort it or anything, but you can, if you're really interested in this, you can go back here, go to this link, and just have tons of fun with the data provided here in a spreadsheet form. Okay, so for ag employers, if you're working with a farm labor contractor, making sure that they are registered by asking for that card or looking them up in this database is going to be help you cover your bases. Make sure that you're working with someone who is legitimate. Okay, so let's talk a little more about obligations for ag employers and associations and farm labor contractors. All of the things I just said. So with the written disclosure of employment terms and conditions, that needs to include the location of the work, the time period the work will cover, the type of work, including the crops to be harvested, the wage rates, including if you're going to do a piece rate, any benefits like housing or transportation, and the cost if workers are going to have to pay for that. The working agreement needs to state that. Whether workers' compensation or state unemployment insurance is provided, and then information about that compensation. The disclosure needs to include the existence of any employee initiative work stoppage or slowdown at the work site. So this would be union type of activities if you're in a union state. Whether the grower or its agents will receive any commissions or other benefits from any sales made to the workers, and any other terms or conditions. Now, when employers or labor contractors need to provide this disclosure depends on the nature of the worker. For migrant workers, who probably are not the majority of who we're dealing with, but they must be provided with this written contract when recruited. For seasonal workers, under the regulations and under the law, they may be informed of a job verbally during recruitment in that initial contact, but then these disclosures must be provided in writing before the work begins, eventually. It may be good practice to always provide this in writing if possible. I understand that there could be some back and forth, but so anyway, the contracts must be in writing, and they must be in a language that the employee understands. You can't, if an employee doesn't speak English, then they need to have a contract in Spanish. And then employers and farm labor contractors Okay, so in addition to this disclosure, they also have an obligation to post notice of employee rights. This must be, so this right here is a specific poster that's provided through Department of Labor. They must post and maintain in a conspicuous place at the place of employment a poster provided by the Secretary of Labor that is directly from the regulations. A note about scams here, I made it myself to myself. Okay, yeah, a note about scams. So in our, yeah, I do have time. Okay, great. In our rural economic development clinic this semester, we worked with a person who was forming a nonprofit. Was it a nonprofit? It doesn't matter. Once they had filed their entity with the state, I think it was a nonprofit formation, but it doesn't matter. Once they had filed with Pennsylvania Department of State, once we had that paperwork in, now their name was in the system. And this person received a notice in the mail. And it seemed very scary. Like they needed to pay, it was like $120 for posters that they were supposed to have in their workplace. And so this person contacted us and we looked at this and it was a scam. It was a total scam. So I was going to go through my email and find where she had sent us a screenshot of this thing that she received in the mail. But I guess just say this to know, scams are prevalent. And so if someone is charging you or your client or someone you know for these posters, that's a scam. These are all available through the Department of Labor for free through PDF download, or you can actually order. I think they're bigger ones. DOL will send you up to 5 in a single order. And they're available in several languages: Spanish, Haitian, Vietnamese, and Hmong, which is Southeast Asian language. So do not pay, certainly not $120 for these posters because you received something in the mail that sounded really scary, like you needed to. Please put out the word that that's not true. Okay, another farm workers' rights kind of general poster. It's hinting at some MSPA language, but it also has some temporary H2A language in here too. I just put this in here to say additional posting can only aid in your compliance. More obligations for ag employers and farm labor contractors besides posting, besides disclosure. They must comply with the terms of any working arrangement. Fulfill your contracts. Do not provide false or misleading information to workers. Do not require workers to purchase goods and services solely from the employer. You need to provide them options that are not you if you're recommending a specific item. This kind of goes back to that list of complaints from 1961. You had the food profiteering going on, as paying people in other money that wasn't actually cash, charging exorbitant transportation fees. So you get these people in this situation and just, milk them for everything they're worth. That's against the law. Also, in that list of complaints was changing wage rates without notice. So another obligation under MSPA is pay the workers the wages they are owed when they are due. They must be paid for all the actual hours of work. From the Department of Labor's Cultivating Compliance Guide, DOL lists several common situations where wage theft can occur, or what they consider to be wage theft, and that would be waiting for a machine to be fixed. So, they're just kind of waiting around. They're waiting for a field to drive, travel between fields during the day. That's work site to work site. That is absolutely paid time. Time at work when the employee is not free to leave the work site, for example, waiting for loading trucks to return to the field. Short rest breaks, like 10 or 15 minutes. Longer rest breaks when the employee is not free from job duties. So if they were, I guess on call doesn't make any sense here, but if they're still somehow susceptible to those job duties, that's time worked. The piece rate must equal at least minimum wage, which is $7.25, and the employers must pay at least every 2 weeks. In addition to paying workers adequately and promptly, employers must also keep all payroll records for 3 years, including information on worker name, permanent address, social security number, the basis on which that worker is paid on the wages, the number of piecework units earned, if paid on a piecework or piecemeal basis, the number of hours worked, the total pay period earnings, specific sums withheld and the purpose of each sum withheld. So if you're withholding something like for food or housing or anything like that, you need to be very clear and transparent about what you are charging for, and then also the net pay. This information must be included in the worker's pay stub or other written type document that's provided to them as record for them, to the employee. Okay. In addition to the disclosure, payment, and record keeping obligations for ag employers and farm labor contractors, MSPA also creates housing and transportation standards for providers of these things. Okay, so let's talk just a little bit about these. Oh, I was gonna make a note to myself. So if you're, well, I have it, sorry. Housing, okay. Note here, state standards here may be higher than federal. I know in Pennsylvania, there's several, I've looked at the chart before, and there's several places where Pennsylvania law comes in higher or more stringent than federal, and then federal law comes in higher or more stringent than Pennsylvania. And I believe our Department of Ag has a chart. We need to find that chart. We're working on it. So in general, for housing, housing providers, whoever that is, must comply with federal and state safety and health standards. The housing may not be occupied until it is inspected and certified. That's probably going to be an area of noncompliance. And then a written statement of the terms and conditions of the occupancy must be posted at the housing site. Here are, according to DOLs, this is from the Cultivating Compliance Guide. This is kind of like a summary of the minimum standards. There are more, I don't want to say there's more than this, but there's more material available than just that guide. To link it there. It's available on the MSPA website for DOL. But I just thought I'd give you a rundown. So minimum standards, everybody's got to have a bed. You got to have hot and cold running water, heat if it's going to be cold, adequate windows, screen doors, lighting. It can't be run, infested with rodents, pests, insects, or whatever. Clean kitchen area with a place to store food so it doesn't spoil. Durable, clean trash cans with lids that keep out flies and rodents. A place to wash and dry clothes. A first aid kit, fire extinguishers, sanitary bathrooms. I'm sure that there are, what does sanitary mean? So there's more regulations than that. Separate toilets for men and women with at least one toilet for every 15 people and an adequate amount of toilet paper. Very important. At least one shower for every 10 people. And the area around the housing should be clean, so no sewage, trash, excessive weeds, whatever. Providers of housing must also post the terms and conditions of the housing in the housing, including the name and address of the farm labor contractor or the employer or the association providing. So who's in charge here? The name and address of, so who owns this? You need to have their name, and then the name and address of the individual in charge of the housing, the mailing address and phone number where people living in the housing facility may be reached, who can live there, the charges to be made for housing, if any, the meals to be provided, the charges for utilities, and any other charges or conditions of occupancy. That needs to be posted in the house. MSPA also sets standards for transportation. So under MSPA, the vehicle must be insured, operated by a licensed driver, and meet federal and state safety standards. DOL's Cultivating Compliance Guide also lists the minimum requirements for transportation. It must include a separate seat for each passenger, seats that are securely attached to the vehicle, windows that are not broken, cracked, properly attached doors with handles that open and close. If anyone here ever had a beater of a car, maybe you had a car that hand, on the passenger side and you had to like get in the other way. That's not a compliant vehicle under MSPA. Adequate ventilation, no holes, no rusted areas, adequate heating, working brakes, lights, turn signals, tires with adequate tread, tires of equal size, working horn, seat belts when required by law. I'm going to come back to that in a second. Windshield wipers, non-leaking exhaust, and side and rear view mirror. I don't know if anyone's familiar with the H-2A temporary ag worker rule that was promulgated last year, I believe. It's since been enjoined more recently. I think it was a federal court in Florida, I apologize, I'm really talking off my head. It was challenged that it was a violation of NLR, National Labor Relations Act, because it provided protection for employees who engaged in collected activity. And so the challenge was that it was allowing rights under NLRA. Recently, a federal court said this is not a violation of NLRA, but more importantly within that, now this is really, it's an H-2A rule, so I understand we're in H-2A land, but one of the parameters of that rule was that it required seat belts for every occupant of a vehicle. And we're talking about migrant and seasonal ag workers here, but once you have an H-2A worker among these workers, the H-2A rules apply. So if that rule, it's still not in effect, it's enjoyed in pieces all over the country. But that was something that DOL was trying to get at through that H-2A rule, is requiring seatbelts for every single occupant of the vehicle. So here you can see that seatbelts when required by state law. So I honestly don't know what states require this and what don't, but just know that that's kind of like a variable in there. Okay, so perfect. I'm doing great on time. Okay, so let's talk just briefly about enforcement. I think that probably like the most, I don't want to say novel, but the thing that stands out here is joint employer liability and a private right of action for workers. I think it's kind of a given that there's going to be administrative or civil penalties and potential criminal prosecution for a law like this that exists in other laws as well. But we've got this joint employer liability concept and then the private right of action. So, okay, so in this atmosphere with, we've got ag employers, ag associations, farm labor contractors, all their employees, potentially processors here, as what DOL is saying. We have multiple parties all interacting with each other, and the relationship between and among them can get blurry. It can be difficult to sort out who is really working for who. So under the law, all parties can potentially be held liable for MSPA violations, all employers. So joint employers, take this down. Joint employers must ensure that employees receive all MSPA rights. And that would be like the terms and conditions of payment, the wage payments, written pay records, etc. A farm labor contractor license, just because someone holds that license or certification from DOL, that is not enough to render them an independent contractor. If a situation arises where Department of Labor is going to assess whether an entity is in fact a joint employer, and I apologize, I just assume I'm talking to a bunch of attorneys, but if you're not, a joint employer means that you could then be held liable for violations. So instead of just going after the farm labor contractor, we're going to go after the farm labor contractor and the ag employer and the association. And ultimately we're looking for money. I mean, that's what we're looking for. So whoever we can attach to that on a claim, that's who we're going to go for. And we're going to do that through the behavior of the parties. So DOL is, if a situation arises where we're looking at who is really the employer here or employers, are there more than one? DOL uses the economic dependence or economic reality test. So we're going to look at a lot of factors around the situation to analyze, is this person actually economically dependent on this other person who would then be their employer? So they'll look at, so I think if you can imagine this in terms of a farm labor contractor and an ag employer or a farmer or landowner, they're going to look at the nature and degree of that farmer or landowner, the alleged employer's control as to the manner in which the work is performed. So if you have a farmer who's saying, hey, you need to go out on this day and this day, you need to go to this place, the more control you're exerting, the more that looks like an employment situation. Also look at the alleged employee's opportunity for profit or loss depending on managerial skill. So an example that would completely negate profit or loss would be a salary situation. We'll also look at the alleged employee's investment in equipment and materials required for the task, or the alleged employee's employment of other workers. whether the services rendered by the alleged employee requires special skill. So this is where, not applicable here, but if you think about, when we talk about general employment, we go, who's an independent contractor? A plumber going into the offices of Microsoft, right? That's going to be is that plumber working for Microsoft? Is that plumber employed by Microsoft? Probably not. Also, did I get here? If I look at that last point, the extent to which the services rendered are an integral part of the alleged employer's business, and then that special skill required. Those are going to show that those are going to go towards that plumber not being an employee. So here in that farm labor contractor situation and then a farmer situation, I don't know. Is there special skill involved? Maybe. I think you can make the argument there. And then also, I kind of skipped around, the degree of permanency and duration of the working relationship. I'll note again that in the regulations for this law, the general assumption is that employment is not temporary. So if we're looking at, is this person an independent contractor or are they an employee? An independent contractor would probably have potentially more of a temporary, non-permanent type relationship. And you might be thinking, okay, if you're interested on this, this is just touching the tip of the iceberg on this type of analysis, but just know that it exists. So you might be thinking, what about housing and transportation? Are ag employers who don't provide housing or transportation, could they still be liable for MSPA violations? Department of Labor says no. These are different. Department of Labor says, MSPA does not impose responsibility for housing and transportation standards on an employer. A person is responsible for MSPA covered housing only if that person owns or controls the housing occupied by a migrant agricultural worker. A person is responsible for transportation requirements only if the person is using or causing to be used any vehicle for providing transportation. And the fact that a person may be an agricultural employer or a joint employer does not necessarily mean the employer is also responsible for complying with MSPA housing and or transportation requirements. So if you are not providing the housing, you don't have to worry about being held responsible for somebody providing terrible housing, basically. Not non-compliant housing. Let's go with that. Okay. Okay, one last or close to last thing. Let's talk a little bit about the private right of action. This is where I realized I probably should have had one more slide. So the law allows a worker to sue directly for violations, particularly when wages, obviously any violation, but that's what's going to happen is usually it's wages that haven't been paid or less than what was owed. And I just wanted to read the piece of the statute here because it's pretty expansive. A lot of statutes, I don't want to say because I'm off the top of my head, I'm going to get it wrong, but a lot of statutes require that you exhaust other opportunities, you go through the department, you do of these other things. Here's what this says. Any person aggrieved by a violation of this chapter or any regulation under this chapter by a farm labor contractor, agricultural employer, agricultural association, or other person, one of their employees, may file suit in any district court in the United States having jurisdiction over the parties, without respect to the amount in controversy, without regard to the citizenship of the parties, and without regard to exhaustion of any other alternative administrative remedies provided herein. So they don't have to wait. They don't have to meet that $75,000 amount in controversy to make it into a federal district court. They can just file suit with the correct jurisdiction. And that's, to me, I don't want to say extraordinary, but that's really giving the workers some teeth. And here, just recently, this came out of District of Oregon, Carvajal Farms. Here, the situation was, we have a good example. Here we actually have, the other thing I wanted to mention here is claims here at MSPA, just as I'm looking through cases and things, seem to be stacked with other violations, H2A and FLSA, and so then you can levy multiple fines or allow for more remedies. But this is a good example of interaction with H2A. If you're familiar with the H2A program, one of the requirements of H-2A is that the employer must hire any U.S. worker who applies. So here, the plaintiff was a U.S. citizen and an experienced farm worker. This person applied for work covered by the defendant farm's H-2A contracts in 2019 and 2020 during the first half of the contract period, which is when that employer is required to hire. And the company did not hire the plaintiff and instead hired dozens of temporary non-immigrant H-2A workers. The jury here found the farm's action, in addition to being in violation of H-2A, but this also constituted a breach of contract discrimination and was a violation of the working arrangement under MSPA that had existed with this worker. So the jury here awarded the plaintiff $17,000-ish in lost wages and $190,000 in pain and suffering damages. According to the judgment, the plaintiff worker may also seek prejudgment interest, attorney's fees, and cost. So one more point I want to make about MSPA enforcement. I know we're all aware of the funding freezes and the various firings throughout the federal agencies. So it may be appropriate to ask, like, how robustly is this law going to be enforced, particularly in this current climate, which is not exactly sympathetic to rights of anyone who may not be immediately identifiable as a U.S. citizen, and this population is certainly subject to that assessment. States can cooperate in the enforcement of MSPA. Recently, in February of last year, 2024, Pennsylvania's Office of Attorney General signed an MOU with DOL's Wage and Hour Division establishing a formal partnership. Just read a little here. It says the MOU maximizes and improves the enforcement of laws administered by both agencies and provides greater coordination between them. The agencies formed this partnership to more effectively and efficiently communicate and cooperate on areas of common interest, including sharing training materials, conducting joint investigations, and sharing other information as appropriate. So I guess you could note, if you go on the website to this, where this is listed, it's Department of Labor, it says as of 1/2025, information in some news releases may be out of date or not reflect current policies. So I don't know. This exists. So even if DOL is not capable of being cooperative here, I do think that in Pennsylvania, enforcing employee rights is a prerogative of the PA Attorney General. So in summary for this law, I will say that so the Migrant Seasonal Ag Worker Protection Act, it applies when you're hiring, when hiring seasonal and migrant ag workers. It requires farm labor contractors to register with Department of Labor. It sets standards for ag employers and ag associations and farm labor contractors and their employees regarding hiring and working arrangements, concerning wage and terms disclosure in an understandable language, timely wage payment, record keeping, posting, housing and transportation safety requirements. There's also a private right of action for workers that can also, not just the private right of action, but enforcement can, I don't want to say create, but can look for joint employer liability. All employers, wherever you fall, are responsible for ensuring compliance with MSPA. So with that, I will say thank you for joining me this afternoon.
I think that's all for now. So we'll wrap up. Thank you so much, Audrey. This was great. Yeah, thanks everyone for attending.